So our legal update today is why you should employ a servicing agent for an agreement for sale or to accept the payments under agreement for sale, or also other states call it a contract deed or a land installment contract. But it's basically an executory contract that you enter into where you basically agree to make payment over time without having fee title, but having full control over the property. And then when you complete the transaction or you complete the payments, at that point, the warranty deed is recorded. So you have the option basically of having a servicing agent, so a third party who receives and disperses the monthly payments or the quarterly payments or whatever payments you've agreed to make under the agreement for sale. Or you can make the payments directly to the seller of the property, or if you're doing a subject to agreement for sale, you can make those payments directly to the existing lender. But I want to talk about why I think it's important to employ a servicing agent, because it's beneficial for both the protection of the seller and the buyer. So for the purposes of protecting the seller of the property, having a servicing agent, at least here in Arizona, allows the seller to complete a non-judicial forfeiture of the property if payments aren't made. Meaning they don't have to go into court and pursue a judgment of forfeiture if payments are not being made. The fact that they have a servicer in place allows them to avoid that situation or that scenario and allows them to do forfeiture completely outside of the court system, similar to a trustee sale with a traditional note deed of trust arrangement. If you don't have a servicer in place, then you have to complete the forfeiture through the court system, meaning you have to file a complaint, serve the complaint, allow the buyer an opportunity to answer. If they answer, then you have to file motions, presumably a motion for summary judgment or a motion on the pleadings, depending on how they answer. You then have to eventually obtain your judgment. And then from there, your judgment would give you the ability to, forfeit that interest, or that interest would be forfeited as a result of the judgment. But it's going to be a time-consuming and costly process to go through that versus a forfeiture. The timeframes are anywhere from 30 to 120 days outside of the court system, depending on how much of the agreement's been paid. And, there's a whole formula for that to make that determination. So for the protection of the seller and to allow them to do the non-judicial forfeiture, you should have a servicing agent. But also for the protection of the buyer. And the reason why you want a servicing agent if you're the buyer, number one, you want the payments to be going to a servicing agent, a neutral third party who's creating accountings and understandable ledgers and things like that. So that's number one. Number two, you can deliver the warranty deed to the servicing agent or have the seller deliver the warranty deed to the servicing agent in trust. That way, if you complete all of your payments, then the servicing agent just delivers the original warranty deed to you as the buyer and you can record it. Versus if you're making the payments to the seller directly or to the seller's lender and the seller disappears and now you've completed your performance, but you can't obtain that original warranty deed that you need to record in order to obtain fee title to the property, then you're stuck chasing the seller around. Or if you can't find the seller, you're stuck going into court and quieting the title and or obtaining a declaratory judgment action that you've completed your requirements under the agreement. And then you have to wait for that court order, which then effectively gives you title to the property. So for me, the servicing agent is beneficial to both the seller and the buyer, and it is recommended anytime I'm working on an agreement for sale. I want to see my client put a servicing agent in place.
Yeah. And, so many investors that get into agreement for sales just make this mistake because they're going cheap on the deal, right? They hear title, well, I don't need that. Easy enough to do on my own. I can go record this agreement for sale. We don't need that. Lo and behold, there is a statutory requirement that if you want this remedy of forfeiture by affidavit, which is, of course, why they all did it, right? That's why they did it, because they wanted an easy remedy. And, lo and behold, the statute doesn't allow it. So just, it's an easy one to miss, but so vital, such a vital one to know about.